Bismillah ar-Rahman ar-Rahim. Alhamdulillah Rabbil Alameen. Wassalatu wassalam ala Sayyidina Muhammad wa ala alihi wa sahbihi ajma'in. Assalamu alaikum, brothers and sisters. This is Edward Ahmed Mitchell, the Deputy Director of CAIR National, welcoming you to today's episode of CAIR on Air, the Muslim Action Hour. Thank you for joining us. A special thank you to everyone watching online, as well as our listeners on American Muslim 360. I'm here today with my co-host and friend, Danette Zagari Mask, the nonprofit and compliance attorney with CAIR National. Assalamu alaikum, Danette. How are you?
Alaikum assalam, Edward. I'm doing very well. Alhamdulillah. How are you today?
I'm good. Alhamdulillah. It's been a while since we've co-hosted together, so it's fun to be back with you for this program today. Alhamdulillah.
I think since Ramadan, it has been a while. I'm very happy to be here and talking about this issue.
Yes, alhamdulillah. And the issue we're going to be discussing today, inshallah, as you might have guessed from having two lawyers as your hosts, is the Supreme Court. That is the topic of discussion for everyone across our country today. Many of you, if you turn on the news, all you're going to see is live footage of the Supreme Court nomination hearing before the Senate Judiciary Committee of Amy Coney Barrett, who President Trump has nominated to replace Ruth Bader Ginsburg on the Supreme Court. In addition, CAIR today filed an appeal with the Supreme Court related to a very important case of ours. And so there's so many issues that we need to talk about today related to the Supreme Court. It's a great opportunity to educate our community about this issue and to answer your questions about this issue. Danette, I'll turn over to you. Maybe start us off and invite on our guest.
Okay, thank you, Edward. I'm really happy we're going to have Justin Sadowsky here, who is one of CAIR's litigation attorneys. He is a tremendous asset to CAIR and to the American Muslim community and to all of those invested in civil rights all over the country. He's an excellent resume. He's been in litigation for, I believe, the better part of his career as an attorney, and we just love everything about sort of what Justin really brings to the table. He has a stellar writing style. I'm always hearing about his amazing briefs. And I can't think of anyone better to be here talking about this issue today and educating us. I have a lot to learn myself.
Yes, absolutely. Welcome, Justin. How are you?
I'm good. Thank you. And thank you for those kind words. Yes,
no, Justin's awesome. And really, many of the cases we win, Justin is behind the scenes doing great work on them. So we all appreciate it, brother, you and the whole legal team. So start us off, Justin. Just tell us, what's the process? For people who don't know, give us a little civics lesson briefly. What is the process for a judge joining the Supreme Court, the nomination process, the voting process? Just briefly take us through it.
So whenever there's a vacancy, the President of the United States can nominate for the Supreme Court literally anybody he wants. Typically, they nominate an experienced appellate judge, and Amy Coney Barrett is an experienced appellate judge. The nomination has to be confirmed by the U.S. Senate. The House plays no role in this. So the Senate makes its own rules under the Constitution, and the way they have and are handling this nomination in general, the broad structure is the same. The Senate Judiciary Committee, which is a committee made up of, I think, about 15 of the 100 senators. The majority party, which is now the Republicans, gets to staff a majority on the committee. The minority party, which is Democrats, staff a minority. They have a hearing followed by a vote whether to decide it to send it to the full Senate. They're having a 4-day hearing, which is itself very typical. What's atypical in this situation is typically the hearing doesn't happen until the committee has weeks to months to review usually a large voluminous submission of documents about the nominee. That did not happen here because of the determination by the president and the Senate Majority Leader that they want this nominee confirmed before the election. So it's happening on a much shorter time frame, but it's a 4-day hearing. It's usually 1 day introducing the nominee. That was Monday. 2 days of questions of the nominee. That's today and tomorrow. And then on Thursday, there'll be witnesses both for and against the nominee. Those witnesses can be anything from friends of and coworkers of the nominee to law professors who agree or disagree with the nominee, and that's the process. Then there'll be about a week that the The committee will debate the nominee. There'll be a vote, I think, next Friday.
You've got an intruder.
Please.
Remember that classic, the BBC show where the guy is talking about North Korea, war with North Korea, and the kids come breaking into the room.
Yeah.
You might go viral.
Sorry about
You might go viral.
So anyway, the nomination, and the one thing you'll notice about the hearing itself is that nothing will be, Judge Barrett will be asked many questions, and she will not really answer any of them, and that will sound frustrating. I will tell you that has been pretty much the case of every nominee since Judge Bork famously was very open about his judicial philosophy and was not confirmed because of it. And ever since that, most judges or other individuals, for instance, Justice Kagan was never a judge before appointed to the Supreme Court, will not answer questions. And this becomes somewhat of a how can you avoid the question game. And so a lot of people are frustrated with these. And that's very understandable to be frustrated, but that's what you're going to see again today and tomorrow. And then after that, it goes to the full Senate. There'll be some discussion, but before the election, I'm pretty confident there will be a vote. And unless something completely, unpredictable happens, she will be confirmed. Almost certainly on party lines. There may be a few Democratic defectors, but I suspect there will be none, and so she'll be appointed. I think it's 54-46 right now, or 53-47. I don't remember the exact party line, but it'll almost certainly be on party line.
So, with all that in mind, and there's no filibuster, all it takes is a majority vote. How can you talk to us about the balance of the court ideologically speaking right now, and how her nomination might change that balance, and how that could impact cases that are relevant to the Muslim community in particular? Obviously, we can never predict what any judge will do, but generally speaking, what are some of your expectations that will happen to discrimination cases involving the Muslim community, people of faith, other such issues in the coming years if she is confirmed?
So I will say one thing. My own personal opinion about Judge Barrett is that she is going to be a very traditional but run-of-the-mill conservative jurist on the court, not very different than you've seen from Justice Scalia in the past, or maybe Justice Alito, or Justice Kavanaugh, and her being on the court itself is probably not going to make much difference to the court. It's that she is replacing Justice Ginsburg, who was very much not in that mold. Justice Ginsburg was a former lawyer at the ACLU, an advocate for civil rights, a very liberal, progressive justice. And so that's going to change things somewhat. The reality is even with Justice Ginsburg on the court previously, there were still 5 Republican nominees, and the center of the balance of the court was typically Justice Roberts, who has been described as somewhat of a swing justice, but he is still a fairly conservative justice, a career Republican politician who interspaced that career with working at large law firms before he became a D.C. Circuit judge, and then Chief Justice of the United States as an appointee of George W. Bush. So some of the changes are going to be those cases where Chief Justice Roberts was persuaded to go with the liberals in often political cases. We saw him go with the liberals in the census case, for instance. I think that case, if it came today, whether they could ask immigration questions on the census, when those immigration questions were, in my personal view, plainly pretextual, probably would come out the other way with Roberts no longer being the deciding vote to join with the liberals. But ultimately, the court's still going to be conservative, and it's still, so there were already going to be issues with the minority voting rights and gerrymandering. The Supreme Court's already weighed in and have limited those rights to a large extent. We see rulings in terms of healthcare and economic issues tending to be very fairly conservative. Religious freedom tends to be a bit of a mixed bag because the conservatives tend to have fairly idiosyncratic views on religious freedom because many of them come from religious conservative background. Justice or future Justice Barrett has, but so has amongst others, Justice Gorsuch. It's in fact, I think if all of the conservatives that will be on the court are actually Catholic, and are fairly religious Catholics at that. And so they may be more open to religious freedom cases. But we've also seen in the past, I mean, for issues with the identity of the plaintiff really mattering in terms of whether religious freedom is supported by the Supreme Court, which often has a lot of discretion over its own docket. So, for instance, when a Muslim prisoner who was on death row wanted his imam there to be with him when he was killed by the state, the Supreme Court wouldn't take the case. But when a Buddhist inmate who was being represented by a conservative Christian legal group made the same petition for him to have his religious advisor by his side when he died, the Supreme Court did step in. So on the one hand, it might actually be good for religious freedom cases, although that depends a lot on context and we just don't know. On the other hand, discrimination, 14th Amendment cases, the conservatives tend to construe that fairly narrowly. And so for cases involving discrimination, that's going to be a bigger problem. For cases involving the Establishment Clause, the conservative justices tend to interpret the Establishment Clause very narrowly.
Gotcha.
But what I think is actually interesting is less that Barrett's adding to the court, changing the composition, which will change it. But I think that a lot of people find it very unfair. And I'm not taking a position on this personally, but I think a lot of people find it very unfair. And we've heard calls to quote unquote pack the court, which means to add more justices to the Supreme Court. Because if the Democrats do take the Senate and the presidency in the November election, it's possible for them to add justices to the Supreme Court and in that way change the balance to make it more representative of America broadly instead of the more conservative court relative to the people it is today.
And it's true. Do I understand that there's no limit, really? It's arbitrary, or how did we arrive at the number of justices that we have right now? And really, what is the hurdle to expanding it? Is it just a political obstacle?
So I think it's been traditional. I mean, there was, I think originally, and I don't remember the exact number, but there was originally much less than 9 justices of the Supreme Court. And that number actually changed a bunch of times at the beginning of the year. We actually had the first time we ever saw court packing was really early in the Supreme Court when a very similar event happened and Chief Justice Marshall, not Thurgood, John Marshall was appointed to the Supreme Court. Was appointed in similar circumstances right now with an outgoing president and leadership of one party and incoming of the other. And one of their responses to that was to add seats. But the seats have been at 9 for over 100 years now. And famously, when there was a conservative Supreme Court during the FDR administration, FDR threatened to add justices to have a more, Supreme Court that was willing to allow his agenda to go through. He ultimately never did that in large part because one of the justices, it turned out later, we found out for reasons that had nothing to do with that threat, became more liberal, and the very divided Supreme Court started accepting the elements of the New Deal it had previously been rejecting. So we've just been at 9 for tradition for a long time now, but it's not in the Constitution that there's 9, it's just a statute. So statutes can be changed by the normal legislature means of having a majority in the House, a majority of the Senate pass a bill, changing it, and then the president signing it, or in theory, Congress overcoming a veto.
Gotcha. So Justin, if you're watching the hearing, many of us are hearing this debate about originalism versus, living constitutionalism. Can you explain, to our viewers, what is this debate about legal theory? In fact, for those of us who are Muslim, it may sound somewhat familiar in terms of debates about religious interpretation, but can you explain to them what the big divide is in terms of constitutional interpretation between these justices?
So, a lot of people talk about these originalism versus conservatives will call it living constitutionalism, but I think there's different terms for it. Some people call it structuralism, or just incrementalism. But between the way we used to interpret a constitution, I can't remember who said this is a constitution we're expounding. It's and originalism. It's based on an idea that originally people looked at a variety of sources to determine the meaning of a constitution, and the conservative movement, starting in the early 80s, has led to this dominant originalist theory. And the theory is that you can only interpret legal texts, and in particular statutes and the Constitution, by what's called the original understanding of it, which is what somebody, as an outsider, the day it was passed, would have understood it to mean. And what that means is indecipherable, especially when you're talking about a 18th century Constitution passed, and talking about a question about like whether looking into a cell phone is a violation of the Fourth Amendment. Well, what would an 18th century passerby think the Fourth Amendment had to do with cell phones? They didn't know what a cell phone was. And so the argument has been from liberals, much the argument that conservatives have made against liberal interpretation, that it's all, a kind of, it's all a charade, and they're just picking their favored policy views and trying to justify it through the language of something that is not malleable, but it's really all malleable, and is the argument made. And I tend to support that view, that on both sides, that politics is sort of not something you can't take away from the process, that people are always going to see questions of what the Constitution means from their prior views. And so even if the Chief Justice Scalia or Chief Justice Roberts thinks he's being steadfast to an original understanding of the Constitution, I mean, that's, he's biased by his own political views, and he's ultimately acting as a sort of a political representative in pushing those views in Supreme Court cases.
Well, Justin, what do we say then about the separation of powers? Because it's a very pessimistic view, even if it might be a very realistic view. I can understand where you're coming from. The being appointed to the Supreme Court, they stay on for so long. The life expectancy at the time when Supreme Court justices were first appointed was much less than now. So they stay on the Supreme Court a lot longer. There is a very charged political process that goes into it, and if we accept the viewpoint that then they are beholden to the political mindset of the powers that put them into that place, do we really have a distinct separation of powers?
Well, and that's a question that we've always been struggling with throughout history. If you look at like the Dred Scott case in the 1800s, right, you had a situation where there was a political compromise over slavery, and the Supreme Court, we think of the Supreme Court, when talking about a separation of powers, of being able to enforce people's civil rights, even when political majorities don't want civil rights. We talk about counter-majoritarian, but there in Dred Scott, what they did is even though the legislative branch and the executive branch came together to grant civil rights to Dred Scott, the Supreme Court actually went and took it away, saying that Congress couldn't outlaw slavery in the territories, and preventing Dred Scott from relying on the compromise, the slavery compromise back then, to free him. So there's always people think of the Supreme of constitutional law and separation of powers as something that's always a net good, and it can be a net good, but it can also be a net bad. It really just depends on both sort of where the Supreme Court is and where it is related to both the people and the popular view and the other branches, because it can be a provider of positive liberty, but it could also be a taker away.
No, that's interesting. I mean, it's complicated even to lawyers to some extent, I dare say. But I think the one of the nice things about our system is that a lot of this happens in the open. You listen to these arguments, you can read these cases. They've become somewhat more decipherable in recent years. Some justices are actually pretty humorous in their writing, and so you can really get a little bit of insight into how our system works and what goes into reaching these decisions that impact so many people's lives one way or another. Justin, let me ask you, CAIR today just filed an appeal with the Supreme Court about a case that's very important to, I think, not only us, but many Americans in the workplace. Can you tell us a bit about the case that we just filed an appeal for?
So as part of the Civil Rights Act in Title VII, the Congress afforded all American workers religious liberties. And one of the religious liberties they afforded Americans was that if you had needed a religious accommodation, if you needed to go and pray on Friday for Jumas, if you needed to wear hijab, or I'm Jewish, so if you needed to wear kippah or not work on Saturdays because that's your day of rest, that employers would need to provide that accommodation unless it was, in the language that Title VII uses, an undue burden on the employer. And the Supreme Court held was, not the Supreme Court, what the Sixth Circuit, which is the case we're trying to have the Supreme Court read, had held is if there was a collective bargaining agreement in place, which a lot of employees have in the collective bargaining agreement, and somebody sought a religious accommodation, the very fact that the employer claims, regardless of whether it's true or not, the very fact that the employer alleges that the accommodation sought is somehow in conflict with this collective bargaining agreement means the court can't hear the case, and the case has to go to a labor arbitrator, which may not have authority at all to enforce the civil rights laws, which basically means the case could go away entirely, and you basically have to choose. But if by joining a union that has a collective bargaining agreement, whether you're going to have constitutional rights or labor rights. And we think that decision was very wrongly decided. We thought that it was for two reasons. One of those reasons is because the labor laws that we don't believe, and I think a majority of circuits have decided that although Congress said that certain decisions that turn on a collective bargaining agreement have to go to a arbitrator if they are in conflict of a collective, or potentially in conflict of collective bargaining agreement, we don't believe the Civil Rights Acts were considered among those. And that's what a majority of courts have held, but not the Sixth Circuit. Another reason is that most circuits agree, because the Supreme Court has said, that a defense to a claim, such as a civil rights claim, doesn't go to an arbitrator only when it's part of the claim itself. And the Sixth Circuit, which we're appealing, said, well, whether an undue burden, whether a accommodation is an undue burden isn't an affirmative defense. It's something the plaintiff must establish, which we think is very much in conflict, not only of what the Supreme Court has said and what other circuits have said, but with the language of the statute, which says, unless the employer shows an undue burden. So I just don't understand how the Sixth Circuit came to that decision, given that language, and we're asking to take another look at it.
So do you think this might go all the way? Could this be a case that you might be arguing before the Supreme Court with this difference of opinion among the circuits if it hasn't been decided by the Supreme Court?
Well, if in this particular case, we're working with co-counsel. So Carl Cesari, who's a good friend of mine and who's an amazing lawyer, teamed up to us with that case. And if the Supreme Court takes it, he will be the one arguing this case, and he will do a great job. All I will say is the Supreme Court takes very few cases that are asked. So I think they take less than 5% of all paid cases, like cases where you have a lawyer representing the plaintiff, and maybe I think close to 1% of all cases. But if they're going to take, our case, we think is amongst the strongest. So we think if they're going to take a case, this is a good one for them to take.
And the underlying issue, just for people who don't know, is this is the Muslim flight attendant who worked for ExpressJet, and she had a religious accommodation that allowed her to essentially avoid serving alcohol to the plane. If a passenger wanted alcohol, another employee would serve it instead of her. The airline canceled that religious accommodation after some time, fired her. Obviously, CAIR sued. And then we ended up with this issue of whether or not the courts can hear it or has to go to a labor arbitrator. So that's the client. Many of you may know her from Michigan, I believe. Is that correct, Justin?
Yes, from Michigan. And if the Supreme Court doesn't take this case, she may never get a judge or an arbitrator, depending on the arbitrator's authority, to be able to tell her and the employer whether the employer's conduct violated the Civil Rights Act. She might not never get her day in court at all.
What if, let me ask you, if it goes to arbitration, right? Could a court, and the arbitrator rules one way or another, it does violate, it doesn't violate, it is relevant to civil right, not, could a court then review the arbitrator's decision and revive the civil rights issue, or does it die with the arbitrator?
So this isn't my area of expertise, but my understanding is there are very limited ways to review an arbitrator's decision. But it would only be based on things such as whether the arbitrator was inherently biased and not the correctness of his or her decision. That's not something you can typically get reviewed by a court.
Gotcha. So it wouldn't be de novo. The standard review would be
no, it would definitely not be de novo. It wouldn't even be typical deferential. It would almost be for an infection of error that can't be cured is almost the standard.
A fatal flaw with the process itself, not the substance of his decision. Gotcha.
Correct.
Well, then let's hope that you win at the Supreme Court, inshallah, and that this case goes before a judge who's equipped and qualified to consider the law and what it says about whether or not this can be done to a person of faith who's just trying to do their job while practicing their faith in the workplace. So, Justin, thank you so much. Adena, do you have any final questions before we let Justin get back to work?
One final question, actually, that's thank you so much for, first of all, for all of the insight that you've given us. And I didn't know that you're a historian practically, Justin. So you have a lot of historic knowledge about Supreme Court cases and the composition of the Supreme Court. So that's a real treat for my day. I wanted to ask you, in terms of the legacy of these two Supreme Court justices, Ruth Bader Ginsburg had, was a very distinct legacy. She became kind of almost an idol for some people in terms of her following. And now it was announced that it would be a woman, that this administration would be putting forth a woman as its candidate for this position. How do you think the legacy of these two women, if she is appointed to the Supreme Court, will be different?
I mean, I think they'll be very different. If you you look at, for instance, Thurgood Marshall, who was the first African-American Supreme Court justice, and how, he is, which was a groundbreaking thing. And now Ginsburg was not the first women justice. That was Sandra Day O'Connor, but Justice Ginsburg was a groundbreaking lawyer for women's rights, and she's going to always have that history and that echelon. Amy Coney Barrett has been a wonderful law professor in terms of her academia. I'm not talking about the merits of it, but in terms of the quality of her analysis. She's been a well-regarded circuit judge, but she's not a women's rights lawyer. She's a excellent conservative jurist who happens to be a woman, and that's beyond that, what her legacy is going to be is going to depend on the decisions she makes and the way she goes on that.
It'll be interesting to follow that. Thank you so much, Justin.
No problem. Time will tell, inshallah. We'll see what happens. Thank you so much, Justin, for joining us. We'll look forward to seeing your next piece of wonderful work out of the legal department. We wish you all the best.
Thank you.
And we thank you all for joining us on today's episode of CAIR on Air, the Muslim Action Hour. We hope that this was informative and educational regarding the way our legal process works and the way the Supreme Court nomination process works and the way constitutional law is interpreted, for better or for worse. If you have any questions for us or for Justin, feel free to leave them in the comments and maybe we can address those later. And Dana, I'll let you close us out, inshallah.
It was a great hour. Thank you so much, or a half hour, for spending time with us. And I encourage you to come back and enjoy more programs like this with us at CAIR.
Absolutely. Thank you, everybody.